Important news. As Judge Annalisa Torres gets ready to make her final ruling, the legal battle between Ripple and SAC comes to a head. The SAC's last response to Ripple's request to seal important financial papers was sent on May 20th, 2024. The SAC says that public access is very important to make sure that rules are followed and that things are clear. The SAC says the information is important and up to date, while Ripple is worried about losing business. A huge decision that could change how crypto is regulated is about to come out. Don't forget to like, share, and follow. Now let's begin. We are going to start with breaking. The House has agreed to the Deploying American Blockchain Act of 2023. Over Ripple and XRP, this takes away SAC's power. There we can see that the Secretary will be the President's main policy advisor on how to implement, use, apply, and make blockchain technology or other distributed ledger technology more competitive. Tokens and tokenization are used in apps that are built on blockchain technology or other distributed ledger technology. Next, Ripple will show off funds in Brazil to help local XRP system projects. And in Brazil, the central bank is almost done completing crypto rules this year. The year 2024 will be important for XRP. Riplanet is the set of rules that lets banks and other financial institutions use XRP and other digital assets like stablecoins backed by real assets for trade and deals across borders. The private meeting between Sachs and Sunshine that was supposed to happen on May 23rd, 2024 has been cancelled. Behind the scenes, Ripple vs. SAC is over. We can see that the meeting has changed. The secret meeting that was supposed to happen on Thursday, May 23rd, 2024 at 2 p.m. has been cancelled. Next, I would say that XRP hit resistance. You can see where the moving averages meet, and it seems clear that if we get through that and break those recent highs, we should be able to squeeze higher and build a floor back in the symmetrical before the possible explosion. The CC made two well-known exceptions if they accept Ethereum ETF. This means that XRP ETF will be coming soon, right after Judge Annalisa Torres' final decision in a Ripple case. Isn't that a coincidence? Guys, put on your seatbelts. Ripple vs. SAC last court document filed while Judge Reddy's decision. Ripple and the SAC are now in the final stages of their court case. The court will make decisions on important issues that will have an impact on how cryptocurrencies are regulated in the future. The legal battle between Ripple Labs and the US Securities and Exchange Commission has hit a key point. The SAC's most recent court filing is the final submission that will decide the outcome of this important case. In response to Ripple's request to keep some financial records secret, the SEC filed a full response on May 20th, 2024. In other important evidence, the SEC's leader to Judge Annalisa Torres strongly opposes Ripple's request to hide financial data and contract terms that are needed for the court to make a decision on the SEC's position is based on the idea that the public should be able to see court papers, which is important for openness and accountability. The SEC uses Lugos Vispermirko van Agdaga to stress how important public access is in cases involving the public interest and the implementation of regulations. The public has the right under common law to see court papers. This right comes from our country's strong belief in openness. Even though the SEC agrees to keep 5 documents secret, it does not agree with Ripple's request to hide important financial information and contract terms. These include information about Ripple's finances, the amount of XRP that has been sold recently, and details about income and costs, all of which are necessary to determine compliance and possible penalties. The CC doesn't like how Ripple is trying to hide this information, as Ripple wants the public to judge the CC's position, and it can't hide the evidence that supports that position at the same time, as the SEC says this shows a conflict between Ripple's public and legal stances. Ripple says that sharing private financial information would make it less competitive. The CC disagrees and points out flaws in Ripple's reasoning about how important and private this information is. The SEC says that if an item is found to be important and within the scope of Article 3 judicial power, it must be given access based on that role. The CSE also says that some of the information Ripple wants to keep secret is out of date, claiming that old records probably won't have a big effect on how Ripple does business now. Still, business records can't support the need for harm finding, as the SEC says. As Judge Torres gets ready to make a decision the crypto industry closely watches, the stakes are high because the SEC wants fines and penalties about $2 billion, while Ripple only wants a $10 million maximum penalty. This is because Judge Nedburn has to decide whether Andrea Fox is a summary witness or an expert witness, which could make the case even more complicated. What happens in this case will have big effects on the Bitcoin business. For regulating other digital assets under US securities laws. On the other hand, a positive decision for Ripple could make the industry stronger against regulatory challenges and make it clear what the rules are for digital currencies. Both sides have made their last arguments in the Ripple vs. SAC case, which is now in its final stages. The SAC's demand for open access to court papers by the public is a strong example of accountability and digital assets regulation. The future of cryptocurrency regulation is uncertain as the industry waits for Judge Torres' decision, which could have an impact on the scene for years to come. Next is SAC vs. Ripple. In the XRP case, legal analyst Bill Morgan points out SAC's mistakes. People in the crypto space are still interested in the never-ending court case between the SAC and Ripple apps. The CC did not agree with Ripple's request to sit in and redact some evidence related to the parties' discussion on remedies. Bill Morgan, a legal expert, has said that the SEC's position is wrong. and that there are important differences and inconsistencies between the types of contracts that Ripple makes. The things that Bill Morgan said about the SEC's position. Bill Morgan, a legal analyst, used social media to make fun of the SEC's resistance to Ripple. He pointed out flaws in the SEC's arguments and said that the agency didn't seem to understand Ripple's on-demand liquidity contracts. Morgan said that the SEC made it clear that none of the sales to institutions were discounts for ODL contracts. As he talked, he said that ODL contracts force customers to buy XRP at market prices and use it for transactions instead of investing it. The SEC's case that Ripple institutional contracts should be seen as investments is weaker because of this important difference. SEC's case against Silly, in its letter to Judge Torres, the SEC gives several reasons for why it is against Ripple's move to SIL and reduce evidence. First, the SEC's opposition is based on public interest and transparency. The SEC stressed how important it is for the public to be able to see papers in court cases, especially in high-profile enforcement actions. The CCC said that the common law right of the public to see court documents has deep roots in the past of our country. They used the case of Lugos v. Pyramid Co. of Anaga as an example. The CCC said that the financial data Ripple wants to redoc is important for the court to figure out what the right remedies are, because it shows Ripple's present asset sales, revenues, costs, and investor discounts. Ripple's reasons are just statements that come to a conclusion without any proof. Also, a lot of the financial data that Ripple wants to keep secret is old. The SEC said that keeping secret such old business records is never a good reason to do so, and it won't hurt Ripple today. Overall, Morgan's critic shows how complicated the SEC's case against Ripple is. If the courts agree with the SEC that sealing is wrong, Ripple's financial deals will be closely looked at, as the difference between ODU contracts and other institutional contracts could be very important to the result. And only by understanding these small details can the full amount of Ripple's compliance with the securities law be found, if any at all, and the right remedies found. This is pretty much all the information we have for today's video. Don't forget to follow, like, and share. See you in the next video, and have a nice day.